All right, today let's look at what happens after the arraignment up through really the trial. At least we'll look at some of the vocab terms, some of the things that happen. Now, on a kind of a timeline of things, if the crime occurs here, then the next thing is the arrest and jail, but we've already covered this. We've covered bail and how that works, and the arraignment. At the arraignment, however, after a defendant has been indicted of a crime, charged with a crime, then they'll give their plea, and it'll be guilty or not guilty or no contest. Again, things we've covered before. If somebody pleads guilty of the crime, there's no trial. If you plead guilty of the crime, we skip all of this stuff and get to the sentencing, which we'll discuss and study in a different day. There's no reason to have a trial because you've already told the courts that you're guilty of a crime. However, if someone pleads not guilty, then you keep moving on down this line, and eventually the trial will determine if somebody is guilty or not guilty of a crime. Okay, so we're going to look at what if someone claims that they are not guilty of a crime or they plead not guilty at their arraignment. What are the steps that follow? Well, let's first of all talk about the different people. Okay, and again, these are just vocab words. So the defendant is a person who has been indicted, who has been charged with a crime. The prosecution is the government. If it's a state case, the prosecution is the state of South Dakota, and they are the ones who are trying to prove that the defendant is guilty. The defense lawyers sometimes are private defense lawyers, which means that a person hires their own attorney or lawyer. Sometimes we have public defenders. If you cannot afford an attorney, then the federal government or the state government, depending on what kind of crime it is, will provide one for you. The Sixth Amendment gives us this right, and then the court case known as Gideon versus Wainwright established that is that we have a right to an attorney if we can't afford one. So a public defender is representing the defense, the defendant. Or, again, they can get their own public defender. The state, the government, is prosecuting the case. Victims don't have to get their own lawyers in a criminal case. The state plays that role. Sometimes what we'll have is a plea bargain. And a plea bargain is an agreement between the defense and the prosecution. And basically it is a deal. That if you plead guilty, we will do something. So it may be, hey, we'll drop a number of charges in exchange for a guilty plea on this. Let's say that somebody burglarized a house, they also stole a car, and did a few other things. Say, okay, we'll drop the theft of the car if you plead guilty to the burglary of the house. And then the defendant can decide, hey, do I want to accept that, or do I want to plead not guilty and take my chances in court? Sometimes they'll drop charges, sometimes they'll lower. Maybe someone was charged with, let's say, second-degree murder. I said, all right, if you plead guilty to voluntary manslaughter, if you plead guilty, we'll drop the charges to voluntary manslaughter instead of murder. And again, the defense may or may not take that plea deal, and not always is it offered. However, less than 10% of all criminal cases actually go to trial. So that means over 90% of criminal cases end in a guilty plea, and many of those there is some kind of plea bargain involved. Both sides may agree to a plea bargain. The prosecution has the role of proving that the defendant is guilty, and guilty beyond a reasonable doubt. We say that the prosecution has a burden of proof, and they have to prove that guilt. And they may feel like we know the person did it, but we may not have enough evidence to convince a jury. The defendant may know that they're guilty of a crime and want to make a better deal so they don't have to spend as much time in prison. Or they may feel like this is the best they can do, that the evidence is going to point to their guilt, even if not. My guess is oftentimes people who are innocent probably don't take a plea bargain, especially if you're facing a lot of time in prison. But plea bargains are a very big part of our criminal justice system. There's a number of pretrial motions. I'm only going to go through a few of them. One pretrial motion, or I guess what a pretrial motion is a request of the court to take some action. Like it says here, they happen prior to the trial. They don't happen in the midst of the trial. A motion to dismiss is after you've been officially charged. Those charges are on you. The only way to remove those is to get those dismissed. Well, let's say that you're charged with a burglary, and let's say that before you are actually tried, somebody else admits to committing that crime. You may ask the judge to dismiss the charges against you. They don't get dismissed very often, but if there's a good reason, they might. A motion to suppress, we've talked about this on search and seizure stuff. This is done prior to the trial. If the defendant believes that evidence was obtained illegally against them, they may try to get that evidence suppressed or thrown out of court, and then the jury will never see it. That's a motion to suppress. It happens at a suppression hearing. Very, very common to make that motion. A motion to change venue is requesting the trial be moved to a different location. We have the right to a local trial. So if you're arrested in Minnehaha County, you will be tried in Minnehaha County. But sometimes a case is so well known that you may feel like you can't get a fair trial in this particular county, and you may ask to change venue, which means to move it to a new location, maybe to move it to Rapid City or Aberdeen, somewhere like that. Sometimes it's granted. Most of the time, trials are not moved. At the trial itself, we have some basic rights. We have the right to a speedy trial and a public trial. A speedy trial just simply means that a trial must happen relatively quickly after the arrest, that you can't be arrested and have to wait 8 or 9 years for your trial. So trials will happen within a relatively short amount of time, probably about 9 months, falls under that. A public trial simply means it's open to the public, that if anybody wants to watch the trial, they can. There's no trials behind closed doors. We want these to be in the open, in front of the public, so we know that everything was done justly. So those are two constitutional rights we have. We also have the right of an impartial jury. Now, an impartial jury means it's a jury that does not have any preconceived notions about if somebody is guilty or not. They don't know a lot about the case. They don't know the individual who's being tried, or witnesses, or the victim, anything that would make somebody less than partial. Okay, so we want an impartial jury, one that is essentially a blank slate. They don't have any, they're not racist against the defendant or the victim, or the police officer who did the arrest isn't their best friend, things like that. So we have the right to that impartial or unbiased jury. The voir dire is a process of choosing that impartial jury. And what we have is a jury pool, a group of individuals who are selected to be potential jurists. And then when a trial is to begin, the first part of the trial is jury selection. So those group of people, let's say there's 50 of them, are called in, and then they have to try to determine, are you impartial? So let's say they go to the first person and say, are you impartial? And you say, well, no, I went to high school with the defendant here. We were friends. Well, that person should not be on the trial. And that person would be exempted or moved out, or at least challenged. And that's known as a challenge for cause, meaning that a lawyer would ask the judge to remove that potential jurist because there's a reason or a cause. And maybe the next person has a cause that they've been following the case closely in the newspaper, and they already believe they know if the individual is guilty or not. Well, they shouldn't be on the jury either. We want somebody who has a blank slate there. So they keep going until they can find the number they're looking for, 12 or 13 jurists who are impartial. That's called the voir dire. The challenge for cause is removing potential jurists who have some kind of bias one way or the other. A peremptory challenge is a lawyer can remove a set amount of potential jurists for no stated reason. They probably have a reason to remove them, but they don't have to state it. So maybe they don't want anybody from age 25 to 30 on there. They could remove a few people from the jury pool for no stated reason through a peremptory challenge. The trial itself, the jury itself, must reach a unanimous verdict, which means that all of the jurors must agree. In order to find somebody guilty, all 12 must believe they're guilty. In order to find them not guilty, all 12 must believe they're not guilty. If it's anything less than unanimous, it doesn't count. So if we have a 8-4 decision, that's known as a hung jury. And a hung jury does not count. It's a mistrial. Okay, so the individual could be tried again. It's not a violation of double jeopardy because the trial ended in a mistrial. So unanimous verdict. And the other thing is beyond a reasonable doubt. The defendant has the prosecution has a burden of proof. And what we mean by burden of proof is they have the burden of proving that the defendant is guilty beyond a reasonable doubt. The defendant does not have to prove that they're innocent. They are presumed to be innocent. It is a job of the prosecution to prove beyond a reasonable doubt that they're guilty. Now, what does this mean? Well, if I'm a jurist, I have to believe without any doubt in my mind that the person is guilty of a crime. If I'm 75% sure they're guilty, that's not good enough. I must find them not guilty because it's not beyond a reasonable doubt. They haven't reached that standard. If I'm 99% sure they're guilty, I think I could give a guilty verdict on that. So all of the jurists, all 12 of them, must believe the person is guilty beyond a reasonable doubt in order to find them guilty. There are some pros and cons with this. I'm just going to briefly go over some of these. We'll study these more in class when we do an activity. So some of the pros are just regular old people. That they aren't professional jurists, that they don't get bored with their job because they do it rarely. Beyond a reasonable doubt means, and unanimous means, it's less likely that a guilty person or an innocent person will be found guilty. It's more likely that a guilty person will be let free because it's a difficult standard to reach, which is good because I don't think most Americans want innocent people put in prison. Some of our cons over here is, it's hard to reach a verdict. Sometimes people may be swayed by appearance rather than facts. We are people, and sometimes we're swayed by those things. Some people may be easily persuaded by others on the jury. Some people don't want to be there or can't afford to miss work. And they do get paid, but they don't get paid much. They certainly don't get compensated what they would miss at work. There may be peer pressure within the jury itself on, somebody may succumb to that. There may be a few strong-willed people that convince others that someone's guilty when maybe they're not. For all the cons that there are, there's no better system, or at least I doubt if we can create a system that is better. We may create one that's different, but it may have some different problems too. So it's not a perfect system, but it's a pretty good system for the most part. Again, we do an activity in class where we study this more, so I'm not going to spend much time on it in this lecture. And sometimes because evidence is suppressed, that the jury is making a decision without having the complete picture in front of them. And again, that's something that we talk about when we do the Fourth Amendment and suppression hearings. Not all evidence is allowed in court. We've talked about some things like evidence that is suppressed, but rumors or biased views are not allowed as evidence because they're not evidence. The evidence is facts, is concrete stuff that can be pointed out to a jury. A rumor is not factual. It's not necessarily proven, so that's not allowed. Hearsay is repeating what somebody else said, but that's not allowed. We have the right to confront the witness. So the witness is a person who saw it. If I see something and then I tell you, and then you are the witness in court, you didn't actually see it. You're repeating what somebody else said, and that's known as hearsay. Any evidence of legally obtained. Now, we've studied this before when we studied the Fourth Amendment, when we talked about the exclusionary rule, so that applies here too. That's where suppression hearings come in. With the criminal procedure, I'm going to quickly go through this, and then we'll stop at the end of this. Each side, both the prosecution and defense, gives a chance to have an opening statement. And what an opening statement is you address the jury, basically giving them an introduction of what you will see in this particular case. Sometimes I think of a trial as being like a well-written paper, where you have an introduction, which kind of catches the reader's attention. Then you have the body of the paper, which is the facts that are being presented, and then you have the conclusion. Well, in a trial, we have an opening statement, which kind of catches the attention. Then we have the actual presentation of evidence and witnesses. That's the facts. And then our conclusion is what we call our closing statements, which is a summary, drawing attention to the best points made. The prosecution always presents their case first. So they will present all the evidence they have and all the witnesses first. Now, the defense can cross-examine witnesses, but if I'm the prosecution and I have a list of 10 witnesses that I'm going to call, I get to call all of those 10 witnesses before the defense gets to present any of their witnesses, or I get to present all my evidence against the defendant. Compulsory process is our right to force people to testify in court. We may have somebody who doesn't want to testify. Maybe they don't want to miss work. Well, the defendant has the right to force people to testify. It's a constitutional right. That is carried out through a subpoena. And a subpoena is a court order to appear in court. Is a court order to appear in court. If you are subpoenaed, if you have to appear in court, then you have to appear in court. And if you violate that subpoena, then you can be arrested. Or you may have your records subpoenaed. Maybe they want to look at your books, your receipts from your business. For whatever reason. I don't know how that would be evidence, but nonetheless, if that is subpoenaed, you have to turn those things over. So compulsory process is your right to force a witness to testify in court. A subpoena is a court order that carries that out. Testimony is simply just the statements that people make while under oath. So if I'm on the stand, if I'm a witness and I make statements that I saw you robbing a store, that's my testimony. I'm under oath when I make those. We all have the right, the defendant has a constitutional right to confront witnesses against them. What means that they have the right to cross-examine any witness. There's no such thing as secret witnesses that aren't cross-examined. There's no such thing as only the prosecution getting their side, but the defense not getting theirs. You have a chance to confront those witnesses. It's a constitutional right. After the prosecution has presented their case, then the defense presents their case. And again, the prosecution can call all their witnesses and all their evidence first. When they rest, then the defense gets to start calling their witnesses. And again, the prosecution can cross-examine those defense witnesses, but the defense then goes second. The defendant themselves never has to answer any questions. They have the right to remain silent, a right against self-incrimination. So that the defendant is the only person that can't be forced to testify in court. They may take the stand, but oftentimes the defendant will decide not to testify in court. Sometimes we have some different defenses. Not sometimes. We have different defenses. And the most common is, I'm innocent. You got the wrong person. I didn't do this. Okay? Another defense may be insanity. We've studied this in class at another time, but basically the insanity defense is, I did it, but I didn't know what I was doing was wrong, is the insanity defense. And again, we've studied this before, so this is just a review of that. Self-defense is, I did it, but I was acting in self-defense. So maybe if someone is breaking into my house and I shoot them, and now let's say I'm being charged with attempted murder. I'm not denying that I shot him. I'm saying, yes, I committed the act. However, I was acting in self-defense, so I shouldn't be prosecuted for this. Entrapment is essentially saying, I did it, but the police made me do it. That the only reason I committed this crime is because the police somehow made me do that. Seldom used successfully. A mistake is odd that you're saying, yes, I did it, but it was an honest mistake. All right, let's say that you left school today and you grab the backpack from the Commons that you believed was yours, a black backpack. You get in the car and drive away. Someone believes you stole their backpack, sees you walking out with it, calls the police, and they pull you over. And you're saying, well, and you're arrested for this, theft of this backpack. Let's say the person had a bunch of money in there. You may say, yes, I took the backpack, but it was a mistake. I didn't know it wasn't mine. Now, there may be circumstances when that is used, but it may not be used that often. This is probably the most common defense. I'm innocent. I didn't do it. Either way, if a jury buys your defense, then you can't be convicted. At the end of the trial, after both the prosecution and the defense have given their case, then they give the closing statements and they address the jury again. Think of it as a conclusion. And at that point, the jury then is instructed on what they can determine. You know, the judge gives them instructions and then they deliberate. Now, again, we did this activity in class where we did jury deliberation. So that's what we're talking about here. They determine if the person is guilty or not. They try to reach that verdict. Remember, they must be beyond a reasonable doubt, and it must be a unanimous verdict, meaning all the jurors must be in agreement. The verdict is simply the jury's decision. To convict somebody means to find them guilty. To acquit means to find them not guilty. So if someone has been acquitted of a crime, it means they have been tried but found not guilty through a unanimous verdict. A hung jury, as I had said before, is anything that is less than a unanimous verdict. And if it's less than a unanimous verdict, it's a hung jury, and the person can be tried again. Now, there is something known as double jeopardy, and the Constitution prevents someone from being tried twice for a crime in which they have been acquitted. So if you are tried and acquitted, found not guilty, you can't be tried again for that exact same crime. However, a hung jury is not an acquittal. Okay, it's a mistrial. And a mistrial, as an example of a hung jury, means that you can be tried a second time because technically the first one didn't count. Or it might be multiple offenses. Let's say that an individual kills 3 people. They may be given 3 separate trials, for one for each murder. That is not a violation of double jeopardy because that is 3 separate crimes. So you can be tried once for each crime. Now, I'm not going to get into sentencing today, but if a person is found guilty, the next step would be sentencing, which, well, let's get into sentencing real quickly, and then we'll get into type of sentence at another time. Sentencing happens a few months later, probably 4 to 6 weeks later. After they've been convicted, there's a pre-sentence investigation, which spells out gives the judge some information, and I'll cover this later in the next section here. There's a pre-sentence report, and then the actual sentencing, where the judge will then issue what the punishment will be. Now, this, again, the sentencing is more complicated. I will cover that in the next lecture. That basically walks us through the steps from here through the trial, through the conviction. You know, the jury reaches that decision. The next one we'll talk about is sentencing in prison.